2007. I'm going to talk a little bit about the work that Chambers does and some of the interesting work that I do and why I really enjoy it. We're then going to hear from Eliza Eagling. She was called in 2015. She's one of the more junior barristers in Chambers, but she's building a successful career, and she's going to tell you about what life is like at the more junior end of Chambers and how to build that practice and how she does it. We're going to then hear from Sarah Hurren. She's on the Pupillage committee at Five Stone Buildings, and indeed she interviewed me for my pupillage, I believe, in the room that Arabella is currently sitting in. Arabella Adams is going to be our final participant this evening. She is Chambers' newest recruit. She was started in practice following the successful completion of her pupillage at Five Stone Buildings in October of this year, and she's going to talk to you about what it's like to be a pupil in Chambers. Obviously, we can't have mini pupils in Chambers at the moment because of COVID. That's a real shame, because mini pupillage is a really valuable experience for aspiring barristers, because it's a really excellent way of finding out whether areas of practice might be for you. I certainly didn't join law school thinking that what I wanted to be was a chancery barrister, but I'm really glad that it's where I've ended up. We're hoping that this webinar can give you an introduction to what life at the traditional chancery bar is, and why we like to practice at Five Stone Buildings, and how you might go about applying to join us as well. It might be a reasonable question to ask, what do I mean by traditional chancery? And I should also say that there is a Q&A box where you can feel free to post your questions, and we will do a question and answer session at the end. We are recording the webinar so that other aspiring barristers can watch it in the future. So if you want to remain anonymous, you can click the anonymous button when your question is typed in, so that you don't get recorded if you don't want to be. So I was asking myself the very good question, what is traditional chancery? What does it even mean? That's a reasonable question to ask. Traditional chancery work relates to the work that was traditionally done in the Court of Chancery before the Judicature Acts in the 19th century. Really, what we mean by traditional chancery is private client litigation, trusts, and allied questions that relate to property law. What we do tends to involve the estates of dead people, the issues arising from trusts, which you might have studied in equity. We also do a great deal of court of protection work, which is work in the court that protects people who lack mental capacity to make decisions for themselves. That is primarily property and affairs work, so to do with property, but some of our barristers also do welfare work, although not everybody does that by a long chalk. We also have a thriving tax practice in Chambers, which involves not only advising on the implementation of tax arrangements to do with inheritance tax and capital gains tax, so personal wealth taxation to do with passing property on to future generations, but also we have some practitioners who specialise in contentious tax and make arguments in the tribunals, both for and against Her Majesty's Revenue and Customs. There are people in Chambers who also have niche practices that deal with pensions, which is a kind of cross between trust law and employment law, and also some people who do specialist real property, although most people in Chambers will be able to do some real property, particularly where it crosses over with the other aspects of private client law that we regularly deal with, for example, proprietary estoppel, undue influence, joint tenancies, that kind of thing. Stack and Dowden claims. So that's the broad overview of what practice Chambers generally has. that means mostly, but not exclusively, working for private clients. It's, I think, great to work for private clients because your work always makes a real difference to their lives. With that comes a great deal of responsibility, because the amounts that at stake are often those sufficient to impact on where the clients are living, and losing a case can have really disastrous consequences. But your work really matters to your clients, and that isn't always the case if you're doing commercial law, working for large institutions. Doing their commercial disputes. So that's one of the, I think, really attractive aspects of private client litigation, which we routinely deal with. I was going to talk to you a little bit about the colour that can come from doing the kind of work that I routinely do. And I thought that I would talk to you about 3 or 4 cases that come within those broad headings of contentious trusts and estates, court of protection, and tax. So I would say often when I'm asked what I do dead people and mad people and tax. But I'm going to not talk about an estate issue. I'm going to talk about a case that I did that involved trusts that I think you might be interested in. So I tend to say that I represented 22 highly endangered Chinese tigers in a divorce. Now that might have you coming up with some questions. I mean, how did you represent tigers, Ruth, you might say? Well, I'm on the Attorney General's B panel, and the Attorney General, as you might know if you've done charity in your trust law course, is able to represent all charitable interests. So I was representing the Attorney General in the Court of Appeal. What had happened before was there was a husband and a wife, not surprisingly, because it was a divorce, and their family breakdown was unusual because they had a structure that they had set up in Mauritius that owned a very large amount of South African land in the Orange Free State. The default beneficiary of which was an English charity, which benefited these 22 Chinese tigers. Now, the Chinese tigers it hadn't gone well for them in general as a species, the Cultural Revolution, because the way in which China developed made their continued existence in China very difficult. So before the trust that I was involved with was set up, there were no Chinese tigers in the wild, and only about 150 that were in zoos. And the wife in my case, who was Chinese, was very passionate about the saving of the Chinese tiger. And she engaged her husband, who was a successful banker, to fundraise and put his own money into this trust for the tigers. She persuaded the People's Republic of China to send some of the tigers to be rewilded in the Orange Free State, and that was very successful. They bred very well because the tigers liked their new diet of springbok, and it went very well. I always thought amusing that they called one of the tigers Tiger Woods. And it came to a point where the marriage really was put under a great deal of pressure by the tiger charity. And the wife fell out with the husband about how the tigers were portrayed on social media. This is literally true. And she was divorcing the husband, and as part of the relief she was asking for a finding that the tiger settlement was a nuptial settlement and could be varied by the matrimonial court. So when this came to the Court of Appeal, the Attorney General wanted to be involved so that he at the time could ensure that the tigers were properly represented and their charitable interest was properly represented. And I took a neutral stance, but broadly ensuring that the trust's interests were properly considered before the court. And the court decided that the settlement was not a nuptial settlement and couldn't be divided up in the divorce claim. So the tiger's land was not available for the wife to get provision for her. So I thought that was a really exciting and interesting case, and really not the sort of thing that I would generally have expected that I would be doing at the bar. That's my first exciting, interesting case. I've got another one, and this one also involved Eliza, actually, so I hope she wasn't planning to talk about it. We both acted last year in a case about a person who was an aristocrat who lacked mental capacity to make a will. He had made provision for his 2 children to give his estate, which included a castle in Scotland, to his children on trust. As his capacity declined, he made a decision to marry his carer. The capacity to marry is a very low threshold, and certainly there was a good chance that he had capacity to marry her when they married. They were living together, she was caring for him. The nature of the relationship was a bit odd, but he said that he loved her. Eliza was a junior barrister for someone else in a different chambers who was representing the son of the aristocrat. I was representing the official solicitor who was acting for him as his litigation friend because he lacked mental capacity. In the end, we did a deal whereby the estate was structured so that the spouse relief, the tax spouse relief that's available to a UK domiciled spouse, as she said she was, could be used to save the bulk, almost all of the inheritance tax on the estate, so that a solution that was monetarily better for the children was achieved. I was disappointed that that case settled, although it was very much in the best interests of my client that it did, because if we hadn't settled, the court would have engaged in some really interesting issues about the test for capacity to marry and whether or not you have to be able to understand, whereas Eliza's client was arguing that a marriage revokes your will. It does in England anyway. We found out that it doesn't in Scotland, which was an interesting learning point for us. Because I was going to argue that part of the relevant information for a decision to marry isn't whether or not your will is revoked. I was going to say, no one ever said I was going to marry Rebecca, but I found out that it revokes my will, so I've decided not to. That is a completely irrational thought process, because everybody can just put in place a new will, and so can people who lack mental capacity, although the Court of Protection has to authorize it in their best interests. So I also thought that was a really interesting case. It had very interesting facts and a bit of salacious detail, and also some very interesting points of law, and that's typical of the cases that I enjoyed doing. I haven't talked about my tax cases, and I am going to briefly talk about a couple of the cases that I'm doing that are very different, that are contentious tax. Both of them are for Her Majesty's Revenue and Customs. Historically, I've been involved in a rather long-running and large case called Ingenious. You might have heard of it because some of the people involved in the scheme are very well known. For example, David Beckham invested in it, Robbie Williams invested in it. That's all in the public domain. They invested in films like Avatar, A Life of Pi, Girl with a Pearl Earring, and they were doing so in order to avoid tax. There was about £1 billion at stake for HMG. And I was involved in a very large 9-person council team that set about showing that the scheme didn't work and the tax was due. I got to cross-examine an expert on film, independent film production in the UK, which was very interesting, although it was a bit embarrassing because I went to the Arsenal where I have a season ticket on the evening, and I found out that I was sitting 2 people down from the person I had just cross-examined, and I was quite disappointed when he didn't seem that intimidated when I turned up. I also got to examine one of the executives at Ingenious, all about the closing of the contracts on Avatar and his relationship and the email correspondence with one of the leading executives at Pathé. So that was very interesting, and I learned a huge amount from the other silks that were involved in that case. There were many silks involved. But I got lots of opportunity to practice my advocacy in a difficult setting, and although it was hugely hard work, enjoyed that too. I want to contrast that with some other tax work that I'm doing at the moment, where I'm the sole counsel for HMRC in relation to the capital gains tax on an old master. We do have a small art practice in Chambers. Many people often say they want to do art law, and I should say that only some people are able to do art law. It's very specialised. Arabella got to do a little bit when she was a pupil, but it's not the main thing we do, but we do some, and we are a leading Chambers for art law. And that's looking at whether or not a taxpayer can avoid millions of pounds worth of CGT by claiming that his painting was plant in a gallery business. So I've been working with HMRC accountants and the policy team at capital gains tax to get all of our arguments together for our statement of case, and it's quite interesting because of the subject matter. So I hope you can understand why I enjoy the practice that I've got. I did want to say that I understand that pupillage application is really competitive, and I wanted to reiterate that if you get some rejections along the way, you've got to take that on the chin. I myself did 21 or 22 pupillage applications. I got 5 first round interviews, 3 second round interviews, and only 1 pupillage, but you can only do one. One's all you need. And I really regard it as the luck of my life that I managed to get pupillage at 5 Stone Buildings, and I'm really happy to be here. So I'm going to hand over now to Eliza, who's going to talk to you a little bit about what it's like to be a more junior tenant in Chambers. Thanks, Eliza.
Thanks very much, Ruth. Yes, I did very much enjoy that case that we did. And I was just thinking that we also had arguments about the marriage because it wasn't consummated, but perhaps that's a talk for another day. But it was, yeah, fascinating case. So I did my pupillage at 5 Stone Buildings, and I'm not going to crash too much into Arabella's talk, but both Sarah and Ruth here were my pupil mistresses. And I enjoyed pupillage, although it is, I guess it is quite a tough experience, but glad to get through it. And at 5 Stone Buildings, we do a 1-year pupillage. So I had a year to get ready, I suppose. And then it is, I think it is maybe quite intimidating the first time, when you suddenly, you wake up and you think, gosh, it's the 1st of October and now I'm a tenant and I have all this responsibility. Although there are a few saving points, perhaps. I mean, one thing is, perhaps every chamber says this, but we really do have an open door policy in Chambers. Obviously not literally so much at the moment because many of us are working from home, although I can see Arabella is in the office. But for example, in normal times, many people's doors are actually open. Literally, you can go in, you can talk to them, you see them in the corridor. Arabella, Ruth and I are all in the basement, and for some reason, we spend quite a lot of time sitting on the floor drinking tea, which surprises clients when they come downstairs to use the client loos, and they think it's a bit of because they've upstairs they're with the barrister with the suit on, and then downstairs we're just in our leggings, talking about law or other things. At the moment, we have a juniors WhatsApp group, which is both entertaining and useful. We have, in normal times, we have real Chambers tea with actual tea, or you can bring your own coffee if you like. At the moment we have virtual tea, don't we? I think, yeah, we have virtual Zoom tea, although I think everybody in the world has got Zoom fatigue. So we're actually trying to think of ways to make Zoom more exciting. So if you have any tips for us, let us know. But I've always found it to be really friendly, and I regularly phone up Sarah and Ruth at the moment, for example, to ask them questions, and everybody always has time for you, and I think that makes all the difference in the world. So not long after I'd started, I actually went off on secondment to Withers, their contentious trust team, and it was maternity leave cover, and that was incredibly useful. And I think we've now really got into a swing of sending people off, again, I say in usual times, either on secondment, or for example, some people have gone off to the Supreme Court for a year. And I found it really helpful going on secondment, because I think you just don't quite understand the pressures that solicitors are under, and the ways in which their working lives are the same and the ways in which they're different. And I think if you can go and spend a few months there with a law firm, then I think you're in a better position to be as helpful to your instructing solicitors as possible, because perhaps you have a better sense of what's going on. And you can also build up working relationships. So I'm still instructed by Withers, and that's been very helpful. I know other people have gone on secondments, they've built up relationships with those solicitors that they worked with. So that I think is a useful thing to do. Now, Reese already talked about that, generally speaking, the types of work we do. So I'll just say what it might be like as a junior tenant. We do quite a number of cases, and in respect to the Inheritance Provision for Family Independence Act 1975, bit of a mouthful. We tend to call it the 1975 Act. If you're a junior tenant, you'll probably either be involved in relatively small estates, or, for example, you might do lead work. So last year, I was involved in the case of Cowan and Foreman. Penny Reid in Chambers QC was leading me, and that went to the Court of Appeal. So that's something you might do. Also on my list, we do quite a lot of estate administration work, and bread and butter for junior tenants is PR and trustee removals, getting those people who have gone a bit mad, gone a bit AWOL, threatening to sell trust assets and, run off with the proceeds, anything like that. And we do that. Caveat removal might not be a word you recognise, but it's to do with the getting of grants in a deceased person's estate. We also do, as a junior tenant, particularly in the first year, private client work, so sort of some tax advice, CGT, IHT, basic trust drafting, like trustee appointments. Reese already mentioned the Court of Protection. Again, bread and butter work for junior tenants, statutory wills. Ruth and I were actually in a statutory settlement case. That's because the person in question was under 18, so you couldn't have a will, so we were going for a trust instead. Trying to think what other COP work. I suddenly gone blank on the COP work. Oh yes, I do a lot of work for the OPG, and some now work for the OS. So for the OPG, their remit is supervising attorneys and deputies. So I've gone all over the courts of England and also Wales. Once. Bad public transport in Wales, I can tell you. Amaze me why they make it so difficult to get to a court. So we get to learn an awful lot about people who have stolen money from people who lack capacity, which is not always that jolly, but there we go. And also common intention constructive trust. I've done quite a lot of advice drafting in relation to that. Which again is probably a talk for another day, but it's basically where you have, say, cohabitants. I don't know where you've got to. Some of you might be just starting your law conversion, but cohabitants, say, who co-own a property, and how it's owned and how the sale proceeds are divided. Reece suggested that I talk a little bit about the balance between being in court and not being in court. I checked my diary, and I think I've got one hearing a week at the moment, and have done for a while. So, but I mean, it's that would just be a hearing of 1 or 2 hours, say, and now and then trials, although a lot of our work settles. And then the rest of the time I will be doing drafting. So that might be drafting correspondence or drafting pleadings, writing opinions, mediations. Quite a lot of our work goes to mediation, and so I've been doing Zoom mediations, which have actually going surprisingly well. I thought that they, don't know what anyone else thinks, but I thought that they might not work as well. And so far, some of mine have gone actually better than I would have thought, perhaps because people are in the comfort of their own homes. And just talk a little bit. I'm trying to think of a couple of cases that I found really interesting. I was, well, Reese obviously taken my Scottish Castle case away from me. Scottish Castle and sex. I mean, you couldn't get better than that. I had a court of protection matter, which was actually more perhaps health and welfare, but I acted for a property and affairs deputy who's a solicitor, and that is the difference between a deputy and an attorney, which is probably a word you have heard of, is a deputy is court appointed. And the deputy phoned me up and he said, well, we had this lady who's she lives in Cardiff, and she's basically watched Netflix or equivalent for her whole life and just had a quiet life. And then somebody contacted her on Facebook and said, would you like to come to Montecito Bay and to come to Jamaica? And she said, great idea. That's exactly what I'd do. So she went on a plane to Jamaica. And turns out this was in the middle of hurricane season. There was Zika virus. She didn't have any of her medication on her. She was in a hut, and then she phoned the deputy up and said, oh, and the person who invited her out has just been murdered. And we had no idea if that was a ploy for money. Actually transpires he was in fact murdered because, as far as we understand, his mate was jealous that he'd got this woman from Cardiff out there and wanted, so there we go. And I was asked, how do we get her back? In circumstances where there was a state of emergency at that time in Jamaica, so it wasn't made straightforward. So that was one of my exciting cases. Also last year I did a case led by Henry Legg QC in Chambers, which was to do with the Human Rights Act, which you might think has no business in trusts, which I think many people still think that, but it was to do with the rights of illegitimate and adopted children, because as a matter of English law, both common law and statute, because of the interaction between the statute and the trust in question, adopted and illegitimate children were out. Interestingly, it was only the trust deed stated that the beneficiaries were male descendants of the settlers' siblings. And we had to compose these letters to the women in the family tree because we were trying to find illegitimate children. And I did get some really rather outraged. It was an all-male team apart from me, so obviously I had the role of trying to write to these women, and I couldn't find a particularly good way of doing it. And we did get some outraged letters back saying, why in 2019 are you asking me if I have illegitimate children, and why do you only care about the boys? To which there was no particularly good answer. And I learned lots of practical things. I mean, it turns out that it's very difficult to use genealogical research to find illegitimate children, because you need to know both the parents' names, but obviously you might not. So if you don't know that they already exist, difficult to find that they do then exist, which is why we were writing to the women. So that was interesting because I actually studied human rights law in my master's. So it's nice to bring that back. I studied French before that, and I don't get to use much French. What else have I got on my list? Ah, yes, practice not killed off by COVID. Yeah, as Reece said, dead people, mad people, and tax, none of which are going away at this time. So in fact, I think we were quite busy. It has been quite an up and down year. I've had some quiet patches, but now just in time for the seminar, it's got absolutely hectic again. But I mean, I sort of reiterate what Reece says. I'm very, very, very happy to be in Firestone Buildings. I consider some of my closest friends to be in Chambers. Very grateful to my pupil supervisors for doing such a good job. And I think the work is absolutely fascinating, and I feel very lucky to have a job that I love and keeps me constantly entertained, or mostly entertained.
Thanks very much, Eliza. I'll give you that £5 later. I just wanted to pick up a few things from what Eliza said. I mean, firstly, it was great that Eliza managed to talk about a case which is literally the punchline to Jamaica. No, she went of her own accord. She mentioned some acronyms that I thought I'd translate for you in case you're not aware what they mean. She talked about the OPG, that's the Office of the Public Guardian, who protects people who lack capacity, where they have attorneys acting and investigates them if they've been doing a bad job, which they often do, financial abuse can be quite rife of people at that capacity. She mentioned the OS, that's the official solicitor, where someone lacks capacity to litigate. The official solicitor is the litigation friend of last resort, and people in chambers frequently act for the official solicitor, primarily in court protection cases.
I'm just going to jump in there and say, to explain to everyone that this is what happens all the time. You know, Ruth and I in the pub, you know, I might start talking, Ruth's my translator.
She mentioned CGT and IHT, that's capital gains tax and inheritance tax. They're capital taxes that frequently arise in our practice. And she also mentioned the Supreme Court, and I thought I would also say that members of chambers are frequently involved in Supreme Court matters in the areas we practice in. Penelope Reid and Hugh Cumber were in Islet and Mitson, and Hugh Cumber and David Rees were in Staveley, which is an inheritance tax case. Hugh went on secondment, as Eliza mentioned, to the Supreme Court, and he's been able to build his appellate practice accordingly, which has been great for him. I'm now going to oh, sorry.
I was just going to jump in and say we've got a few questions. I don't know if I should.
Yeah, I thought I'd do the questions at the end, if that's okay, Eliza.
Yeah, absolutely. Yeah, there's one that might be suitable for Arabella, so she can review that at the same time.
Thanks so much, Eliza. I'm now going to hand over to Sarah, who's going to tell you about the pupillage application process at 5 Stone Buildings. Thanks, Sarah.
Great, thank you, Ruth. And I hear you've promised Eliza £5. I promised her 10, so we'll have to have a discussion about that later. As Ruth mentioned, I'm on the Pupillage Committee in Chambers, and I have been for some time. I just wanted to give you a brief overview this evening, really, about 4 things. First of all, how to go about applying for pupillage at 5 Stone Buildings. Secondly, what the timetable is for applying. Thirdly, what are the qualities we're looking for when we're looking to recruit for pupillage and also for tenancy. And fourthly, well, what's the process once you've put in your application? What's the sort of process between making that application and finding out whether an offer is going to be made? So looking at how you apply for pupillage at 5 Stone Buildings, Chambers is a member of Pupillage Gateway, which is a centralised application process administered by the Bar Council. And we've been a member now, this is our 2nd year of membership, and we think it gives you as applicants really the easiest way in, because you can apply to up to 20 chambers through Gateway, and as many chambers as you want who aren't part of Gateway, but it gives you a sort of centralised application form. Chambers offers up to 2 pupillages per year. We normally offer at least, make 1 offer at least per year, and the pupillage award is £60,000, of which £15,000 can be drawn down in the pre-pupillage year. So the way that the application form works with Pupillage Gateway is that there are some details on it which are common to all applications, if you like. So, for example, your exam results will be the same for every application that you make. But each Chambers gets to ask some specific questions relevant to your application on the Gateway form. So to give a very simple example, we'll ask you, why are you applying to 5 Stone Buildings? And only the Chambers that have asked that question will get to see your answers on that. So I would say a key bit of advice when you come to complete your application form is don't just copy and paste your answers, even if the question is quite similar from a different set of Chambers. Make sure that you're answering the particular questions that you're being asked by this set of Chambers, by 5 Stone Buildings in our case, and that your answers are relevant to that question. So that's the sort of the process. I should say that from the 27th of November, so later this month, you'll be able to see on the Gateway website a practice application form, and also the specific questions that 5 Stone Buildings is going to ask in this pupillage application year. So check out the Pupillage Gateway website later this month, because that will enable you now to start assembling information relevant to your application so you're ready to submit it when the window opens. And even if you're not applying for pupillage this year, I think it's a really good idea to check out the Gateway website and to look at that practice application form now, so that you have an idea what a pupillage application form looks like and what details you'll need to provide when you come to apply. The actual application windows, the time within which you can submit your application for pupillage at Five Stone Building through Gateway, it opens on the 4th of January next year, 2021, and closes on the 8th of February 2021. So you've got a month within which to submit your application once it opens. It doesn't matter when in that period you put your application in, so there's no premium on early submission, because we only get to see your applications when the window closes. So we get, I think, the applications on the 11th of February or somewhere around that date. And then between the 11th of February and the 6th of May is the period within which Chambers can and will conduct its sort of recruitment process. And I'll come on in a bit more detail to talk about that. But typically we do 2 rounds of interviews, probably in March and April, all slightly COVID dependent, the timetable this year, but that is what I envisage happening. And then, because we're part of Gateway, I think now all chambers actually, whether in Gateway or not, have got to adhere to this timetable. Offers are made by the 7th, on the 7th of May, and you will have 7 days if you've received an offer to accept it or not. So that's the timetable. The next thing I wanted to talk about a bit was, well, what are we looking for? I mean, what are the qualities that we're looking for from an applicant? And we've got some very clear criteria which we apply in assessing your application. And the qualities and abilities which we're looking for are actually set out on our website, available on our website. If you look under the recruitment heading of the website, and as part of the pupillage application, you can see the document, it's attached there. If you're in any doubt, can't find it, email us and we can send you a copy. But essentially there are 4 things which are we're looking for, in what no particular hierarchy in what I now say. But the first is, career motivation. So particularly your interest in chambers and our area of practice, and your drive to succeed as a barrister. The second thing is intellectual ability, your ability to analyse, to sift the relevant from the irrelevant, and to process and manage information. I think it's fair to say, as Ruth has said, a lot of our work involves some quite, complex, really interesting but complex legal principles, and the ability to reason really very, very well is a key aspect of what we're looking for. Probably equally important is the ability to communicate clearly, so being clear, persuasive in your arguments, both written and orally. And then the 4th major area of or criteria which we're looking for, kind of more broadly personal qualities, which we can break down into, and we have broken down into some subheadings, which you'll see. But an important element of that is the sort of balance between being able to work independently and being very self-reliant, but also being able to sort of work with other people in a team, because you're always going to be instructed by solicitors, you'll always have clients, you may be part of a counsel team, you may have to deal with experts. There is a lot of actually working with others in what is a self-employed and independent profession. I think what's really important for me to emphasize is that when we're looking for potential of these qualities, we know when you come to apply for pupillage, you're not the finished article. We're very keen that people from all sorts of backgrounds apply to us. And we understand that you may well have had very little exposure to the sort of work that we do and that Ruth and Eliza have been describing. A lot of what we do, doesn't even come up in a 3-year law degree, let alone, a 1-year GDL or, other legal studies. So when it comes to showing interest in our area, that may be demonstrated, as Ruth has mentioned, by doing mini pupillages, but this year, we quite understand that may well not have been possible for people. But reading about us on our website, research projects that you've done as part of your studies, which have sparked an interest in the sort of work we do, those are all ways of showing that you're interested in our work without any need really to have a very detailed knowledge, or having worked in a private client department of a firm for 3 months, whatever. We're not, that's not what we're looking for. We're looking for potential and interest. So coming on to the fourth topic, how do we assess your application? What's the sort of process once you've submitted it? There are 4 stages in assessing pupillage applications. I mean, obviously, the first thing we do is to review your application on paper. And we have a particular scoring scheme which we apply, which is designed to identify the applications which best fit our criteria. We anonymise applications, and we remove details of your school and university, because we think that best ensures that your application is assessed without any irrelevant unconscious bias creeping in. But one thing I wanted to mention is that we do invite you to complete a voluntary questionnaire, which is then used by our recruitment partner, Rare Recruitment, who are an independent recruitment specialist, who can help then put your educational results in the context of how your school or university year has performed as a whole, so that, particularly if on paper it might look like you might have underperformed, that allows us to see, well, that's something actually that we should make allowances for, because compared to everyone else in your year, you've performed extremely, extremely well. So that's the first stage, the paper sift. The next stage is that we invite applicants whose paper applications have passed our sift to do a piece of written work in a relatively short timescale. I think it's perhaps overnight or in a couple of days. And that piece of written work, it doesn't require any prior legal knowledge. We'll give you everything you need to do the problem, to answer the question. And in fact, we prefer if you don't know anything about it in advance. In a way, it's designed to test your ability to analyse and to communicate your conclusions very concisely and precisely. And those answers, again, are marked. And then at that point, successful applicants are invited to a first round interview. And the first round interview is typically done by 2 people, probably, as I said, in March. The interview is about 25 minutes long. And it will involve a kind of mixture of questions which are specifically designed to tease out whether or not you satisfy our criteria, particularly the personal qualities which may not have been apparent from the written stuff that we've seen. So, for example, typically we'll ask you to talk about something you've done in the past, which demonstrates a particular quality we're looking for, and we'll explore with you what you did and how you handled the situation. And then we'll also sort of explore with you your reasoning and communication skills, probably by talking about in a bit more detail about the written problem that you've done, and asking you some questions designed to sort of tease that and test that. So that's the first round interview. And then there will be a second round interview. I should say, it's important to say there's no quota of numbers that go through from the first round to the second round. We'll put through as many as we think have a realistic chance of being offered pupillage to the second round. The second round is an interview with a larger panel, perhaps three I think is what we've been doing in recent years. And it will be a longer interview, perhaps about 40 minutes. But the idea is the same. There'll be targeted questions designed to test the criteria that we're looking for. And you'll probably be given a piece of a problem again, this time to look at and discuss orally rather than doing written work. We might ask you to argue, 4 particular positions, and then explore that with you in the interview. So I'm conscious when I'm describing the process that, this can, and I'm sure does sound daunting. The thing to stress is that, you know, from our perspective, we're keen to make sure that you have every opportunity to show your potential to us, which is why we've got a very structured and kind of multi-layered, multi-stage process. But we'd love to see applications from as diverse a range as possible. Frankly, we think that's the best way of getting, you know, the best pool of applicants and ultimately barristers before us. So don't have any preconceptions really about the sort of person we're looking for when it comes to applying. If you think the work that we do sounds interesting from what Ruth and Eliza have said, and you know, it is very interesting on a lot of different levels, and a very rewarding area, please do think about applying to us this year. And I think that's all I wanted to say. Thank you. Sorry, I'm going to hand over to Arabella now.
So as Ruth said, I finished pupillage at the beginning of October, just a few weeks ago. Everything was on plan, went to time despite the pandemic. And I'm going to talk to you about what pupillage was like at Five Stone Buildings. But also I think the one thing you really get from a mini pupillage is a feel of what it's actually like to come into work at that particular chambers each day. So I'll try to give you a sense of that as much as possible. If you do have any specific or general questions about pupillage, put them in the Q&A. I'm really happy to answer them. The basic structure of your pupillage at 5SB is that you sit with 4 supervisors over the year. You get 3 months with each supervisor. I don't think you could say that you have specific seats in each practice area like a law firm might, but I think there is definitely thought behind your pupil supervisor allocation in terms of what you have and haven't seen already. And they'll make sure that you get experience of all of the key practice areas in both contentious and non-contentious work. In terms of what your day looks like, my hours during pupillage were always 9:30 a.m. to 6 p.m. and a proper break for lunch. I very occasionally came in a bit earlier if I was going to court with someone that morning. You might also have a supervisor who, say, prefers you to come in at 9 and leave around 5:30, maybe because they have to be off earlier for childcare or something. So it does depend, but I think that the basic number of hours you do is pretty consistent as a pupil. There's absolutely no expectation that you work in the evenings or at weekends. And I know you might hear that and think, okay, that's the official line, but is there an unofficial expectation that you should show you're keen by coming in early and staying late? But genuinely at Five Stone Buildings, there's no silent expectation that you'll do that. And I know that because one week early on in my pupillage, I stayed until about 6:30 p.m. for 2 days in a row, just because I hadn't quite finished reading a case or something. And someone came in and said, you've really got to stop staying so late, as if it were 2 a.m. or something. And I literally got chivied out of the door. So people really do want you to take breaks. I think the hours make a huge difference to what your pupillage experience is like, because you are taking in a lot. Most of it's very new. And when you do work, you work hard, you're using your brain all day. But because the hours are so reasonable, I think things just always seemed manageable. I was expecting it to be the most stressful year ever, just because that's sort of what I heard at bar school. But actually, I never felt exhausted or overworked. I had plenty of time to see my friends and do non-law things. And it was actually really nice to have my evenings and weekends back after being a student for so long. As for what you might be doing in the hours when you are working, I found it really depended on what work my supervisor happened to be doing at that time and how far into pupillage I was. I think it's natural to be a bit nervous about the work before you start pupillage and to wonder if you're going to be thrown in at the deep end and asked to do all these things you have no idea how to do. But I realized pretty quickly it just wasn't going to be like that. I was eased into the work really gently. In my first month or two, I mostly went along to court to watch and take notes, either with my supervisor or other people in chambers. I also did quite a lot of legal research, again, either for my supervisor or for other people. Doing both of those things as a very new pupil was actually great because it introduced me to lots of new areas and gave me time to get to grips with them. but it was also a really good opportunity to get to know other people in chambers and to do something useful for them and get off to a good start with them. And when I started doing my first pieces of written work, it didn't feel so daunting because I'd already spent time doing legal research, getting feedback from people on that. And I'd read quite a lot of my supervisor's written work and observed quite a lot by that stage. Also, you aren't just told to do some research or written work and then sent away with no idea how to start. The person setting the work always gave me some suggestions about what books to look in, or maybe pulled out a few issues from the papers for me to focus on. And then the volume and the difficulty of my work was really gradually increased as I learned more and more. And by my third supervisor, I was doing quite a lot of written work. Most of it was live work, so real instructions that he had been given rather than work he'd already completed a year ago. He would send me the papers with a few pointers, then we'd both independently do the work, write the opinion or whatever it was. Then we'd compare our versions and talk them through. And I learned so much from doing that. So to summarize the things you might be actually doing as a pupil, you could be attending court or mediations or client conferences or meetings with expert witnesses, and you'll be either taking a note or observing those. I also attended conferences that we as a chambers put on, or conferences where my supervisor was speaking. You could also be doing legal research, maybe quite a big bit of research for someone else in chambers, or maybe just something small that your supervisor's asked you to look up. You'll be doing written work, so maybe a skeleton argument, an opinion, a particulars of claim or a defense, or you might be writing a letter. And if you're listening to this and thinking, I don't know how to do any of that, don't worry, because you learn the basics of all of those things in bar school, and then you kind of learn them all over again during pupillage. And then I also did some miscellaneous things as a pupil, mostly with Ruth actually, helping with pro bono work. I wrote a summary of a case for the Chambers website. I also co-wrote an article with Ruth for a legal journal. So as you can see, there's actually quite a lot of variety in what you might be doing each day. And you might be doing any one of those things in a completely different practice area. So I found I might be attending an urgent injunction in an art fraud case one week. Then the next week it might be legal research about capacity to marry for a court of protection case, or maybe drafting pleadings in a proprietary estoppel case. And as everyone else has said, I found that whatever I was doing, it tended to involve a person or a family or some particular objects or heirlooms, as well as some quite complex law. So it just couldn't fail to be interesting to me. It's a really good combination. In other areas of the bar, it's quite common for pupils to get on their feet during their second 6 months of pupillage and to actually start practicing and taking their own clients. At Five Stone Buildings, you don't tend to get on your feet as a pupil. You carry on learning in chambers with your supervisors. I was really grateful to have the time to carry on learning. And even though I wasn't really practicing, I still got my provisional practicing certificate. And the clerks looked out for little bits of work that I might be able to do in my own name. And I actually did do an opinion in my own name towards the summer of my pupillage. And I also did deviling on real cases for other members of chambers. So there might be an opportunity to do some work in your second six. And then beyond work, you might be wondering what the more social side of chambers is like. And it's a shame that mini pupillages aren't possible at the moment, because I felt like I really saw that when I did a mini pupillage at Five Stone Buildings. During my mini and during pupillage, I found chambers a really friendly social place to be. You aren't just coming in and working in isolation all day. Well, in normal non-pandemic times, you aren't. People were constantly stopping by my supervisor's rooms to catch up or talk through cases with them. I was also really encouraged to go to chambers tea every day as a pupil, which is pretty relaxed. I really got to know people I might not have seen that much of otherwise. And it's also amazing how much you learn about being in practice just by listening to people talking at chambers tea. I was always made to feel like I was part of chambers. People would often invite me to come to court with them if they had a particularly fun or interesting case or something that they thought would be useful for me to see. And I was invited to all of the Chambers events, to lunch with people, to drinks after work, and so on. Basically, I was expecting it to be quite a stressful year, and actually it was far more relaxed than I thought it would be. You are obviously conscious that you're on show and people are deciding if your work is good enough, but it just felt like everyone wanted me to do well. It was never about putting me under loads of pressure and seeing if I would crack. Everyone was really generous with their time and their help, and it was all about preparing me for tenancy and my own practice at the bar, and just putting me in a position where I could show everyone my best work. Q&A?
Yeah, thanks very much. I'm conscious that Eliza definitely has to go at 6. She's very busy, and we're all very lucky that if we're busy at the moment, so we definitely have to let her go then. But I wonder if I could ask her one of the questions first, which is, what is the difference between 5-stone buildings and other chambers that we're usually compared to? What sets us apart, Eliza?
Are we all mad? No. Well, I would say, we were talking about this the other day, I think we are possibly the most specialist private client or traditional chancery chambers. I mean, there are other places that do it, but we do it almost exclusively, apart from our little pockets of land and art. Does everyone agree with that? Yeah. I think that's one of the main things that sets us apart. I mean, I do think we're very friendly, but I've no idea how friendly other chambers are. So they might also be friendly. I think the 1-year pupillage, which is also linked to what Sarah was saying about how in some ways the area is very, can be very complicated in lots of different ways. We're sociable, but again, other places might be too. Yeah, and we're mad in the best possible way.
Thanks very much, Eliza. One of the other questions that we have is about whether it's worth making an application for pupillage in this round, because the potential applicant has only been able to do 1 mini pupillage because there aren't that many mini pupillages available at the moment. So I was going to mention that I thought there are other ways of getting experience. They might not be as good as mini pupillages, but lots of things aren't as good in COVID as they were before. What you can do is you can go to see other webinars like this. There are some that the Chancery Bar Association have put on, some other chambers do it too. You can watch Supreme Court TV and get a feel for the kind of cases that might be involved in this area. We also have webinars, which we are put on as marketing tools for our own practices, but these can be a great insight into the kind of work that us and other chambers are doing. So I'd encourage you to do that. What do you think, Sarah? If someone's not able to get mini pupillage this year because of the pandemic, should they still be applying for pupillage in January?
Yeah, I mean, I don't think that should put you off making an application, because I think everybody is going to understand, the limits and the difficulties that an applicant this year has faced in assembling mini pupillages. And although mini pupillages are an important way of experiencing what it's like to be in chambers, in a sense, they're much more for your benefit than for ours. And if, as Ruth has said, you can establish that you are interested in the sort of work we're doing in other ways by, as I said, when I spoke about reading or watching webinars or, referring to maybe research projects that you've done as part of your studies, then I don't think it will in any way detract from your application that you haven't done a mini pupillage this year with a chancery set, or the 5-stone buildings in particular. So I would definitely agree. I mean, in terms of the material that's available, also to give you a feel of the sort of work that we do in chambers, a little more of a feel. I did a talk for UCL actually on their Laws Connection course, their first year course, and that's available on our YouTube channel, which gives you a little bit of an introduction into sort of claims under the 75 Act and disputes about wills. So that might be worth watching, as well as our webinars, which are more designed for solicitors to watch.
I'm going to go, by the way, but
thanks very much, Eliza.
See you later. Bye.
One question that we've been asked is what chambers do specialise in art law? Well, I had a look on the Chambers and Partners UK bar site, and we have by far and away the most barristers that specialise in art law. It's just that it's not the core of everyone's practice. So if you come expecting to do exclusively art law, you'll be unfortunately sorely disappointed. I did look at the other places where there are individual practitioners that do art law. There's Joe Smoohar QC at Essex Court Chambers. There's Gilead Cooper at Wilberforce Chambers. There are people at Searle Court. There's somebody at a place called the 36 Group, which I can't say I'd heard of before. And there are some other chambers too. But if you're interested in that, do check out Chambers and Partners or the Legal 500 to see who they recommend. I thought it was interesting that Chambers and Partners don't actually recommend any particular sets for art law. But that's a good idea to see in the directories what chambers are really specialising in and what they other people think that they are actually good at. We've also been asked a couple of questions about non-traditional backgrounds, Sarah. So one of the questions is, what about career changes? Do we welcome people who've had a career before coming to the bar? And there's also a question saying that we all sound lovely and posh, but the applicant comes from a very non-traditional background, and she's concerned that that's not her. She enjoys chancery. Is it somewhere that she would fit in?
Yeah, I mean, absolutely, definitely to both. Career changes, we've actually got a couple of, certainly one member of Chambers who did have a previous career, and one person who's recently, again, had a sort of another career change, who'd come from a previous sort of career background. So yes, absolutely to that. And also, you know, we may sound lovely and posh, but that's not necessarily what our background actually, you know, is. But I think what I really do want to stress, that we don't have a sort of preconception of what a chancery barrister or a member of Chambers looks like. We're working really hard to try to sort of eliminate in our recruitment process any unconscious bias that we might, you know, Chambers people conducting the recruitment process might possibly have when doing that recruitment. So we're actively doing things to try to encourage people to apply from backgrounds that might not otherwise have considered a chancery pupillage. We've, as I said, doing some contextual recruitment as well as anonymisation. So I really would encourage you to give us a go, because I think that's something that we're very conscious of, and we're trying very hard to make sure that, you know, we widen our appeal, if you like, to people who might not otherwise have looked at us, because we want the best, you know, we want the best people from wherever they come from.
Yes, and someone else has said that they think that the composition of the recent pupils, they're concerned about the backgrounds being quite homogenized, although they don't use quite that word. They say they're non-Oxbridge or non-Russell Group. Do they have a fair chance of joining in the application process? And I would say that what we're really interested in is academic ability. Now that can be and often is shown through grades, but we anonymize the universities, but it can be shown in other ways. A solicitor who wants to change to the bar was asking me whether there was any point in doing that if he felt that he didn't have the kind of university degree that many people at the Chancery Bar have. And I said to him that I thought that there were lots of ways in which he could use his own experience to show the academic ability he had, even though that's not in terms of grades. So I would encourage people to apply, and I do understand that there are only so many slots on the gateway that you can apply to, but I would encourage people to apply to the sets that they're interested in the work for, and hopefully that will shine through in the application process. I also wanted to mention to the student who asked the question about coming from a non-traditional background that she, I think it was a she might be assisted by looking at the recording of the race and ethnicity webinar that the Chancery Bar Association recently put it on, and I helped organise, because that talked a little bit about ways in which people coming from different backgrounds have made successful careers at the Chancery Bar. We've got a question about the BPTC, Sarah. Someone said they got a competent. Will that affect their application?
Well, I think it's always important, if you feel there's something about your educational achievements that perhaps doesn't reflect your true potential, to explain in your application form why that is, if there are particular reasons which affected your performance in that exam. And we give you an opportunity to do that in your application. So if you feel that's not a fair reflection of your performance, then do explain. But what I would say is that performance on the BPTC is only one element of your overall academic performance. And so, for example, if you've got a really good degree or other demonstration of your intellectual potential and ability, then we would, that the BPTC result would only be one probably quite small element in the balance.
Thanks very much, Sarah. I've got a question which is, what is the typical career objective considered after 12 months of pupillage? I wondered if Arabella had an idea what her career objective was for 1 year's time.
Oh, for 1 year's time?
Yeah.
I think just building on what I already learned over pupillage, getting comfortable with running my own cases and all the practical things that come with actually practicing at the bar rather than just doing everything in theory. And yeah, maybe appearing live in court rather than over a screen would be good. We'll see.
You might want to have developed some relationships with solicitors and tried to do different things, maybe even got to do one type of case twice, Arabella, if you're really lucky, so you're not having to do things always for the first time.
Yeah, that would be good. And actually feeling for the first time, actually, I've done this before. I have some idea of how it might go. I'm looking forward to that.
Sure. Thanks very much, Arabella. Sarah, in terms of application timeline, yes, what stage of study is it best to apply? Yes. Is this January, February window intended for pupils this year? And can applications be made years in advance if you're still studying?
Yeah, no, let me clarify the timescale. So an application which you make in 2021 is for pupillage, let me get this right, commencing October 2022. I think that's right. So you are applying quite a long way in advance. Is that right, Arabella? I got that wrong.
Yeah.
Slightly quizzical. Yeah. So you do apply, basically 18 months in advance of starting pupillage. So, I mean, the earliest, I suppose, that you could apply is in your final year of your degree if you are doing a law degree. I think that's right. Otherwise, but not everyone will apply at that stage. Somebody might want to do a master's. They might want to take some time out to work out, what they're doing. And I don't think that, I'm not going to be prescriptive about when in your life you apply for pupillage by any means, but the that's the application timetable or timeline.
Thanks very much, Sarah. There's a question about gender and race diversity from Falak. Thanks very much for that. One of the questions is about what the male and female ratio is. So Five Stone Buildings, we're very lucky that half of our silks are female. There are a few more men than women in the ranks of the junior members in chambers, but as you can see, there's plenty of women at Five Stone Buildings and Eliza did joke with me that we might be giving the indication that there were only women at 5 stone buildings, but that isn't the case. You can find out about the difference in ratios of gender at Legal Cheek, that has all the ratios of silks and juniors up on their website. In general, I think we're one of the few chambers at the bar that has as many as half of female silks, but I don't think if you're starting out in 2020 that there's any reason to think that as a woman you can't succeed at the bar. Our head of chambers is female, and I've been really lucky to be at 5 stone buildings and have such great female role models. In terms of ethnic diversity, I think we have 1 or maybe 2 people in chambers who would consider themselves to be part of an ethnic minority. There probably are some statistics that are gathered, but I don't know what those necessarily are for chambers as a whole. But I would say that again, in 2020, I would not expect anybody from a non-white background to suffer discrimination at the Chancery Bar, at 5 stone buildings, or really anywhere at the bar. It's completely unacceptable if people do face those kind of barriers. And I think particularly certainly what I think of the Chancery Bar, it's not where you come from, it's really where you're going that counts. So we would encourage applications from people with all backgrounds. Oh yes, there's somebody, Sarah, that's asked a question about their BSB exams. The BSB have postponed their exams and they can't sit them until September. They don't think that they will have the results in time for the application. Will that have a negative impact?
No, I mean, again, we understand, the difficulties that anybody who's doing studies in this environment is under. So it's not going to have a negative impact. In fact, if you do the exams in December, you'll probably have the results if you're going to be invited to an interview anyway, and you can communicate them when they come in. But it's not going to put you at a disadvantage.
There was a question which I think we wrapped up mostly in the talks that individual people did. There's a question about skills for members of chambers, and I think that Sarah talked about that in terms of pupillage. In terms of making a successful career at the bar, obviously public speaking and confidence is important, academic ability and analytical ability and reasoning is important, people skills are really important, and good strong written work is important. And I think Arabella also covered what the best features of pupillage and training were at 5 stone buildings, and I would say that the exposure to really good quality advocacy and written work is excellent, and the support and work-life balance are also excellent. So there's a question from Gary, Sarah, which is that a student can apply 18 months before they intend to start pupillage. The question is, what about earlier, so 24 or 36 months time? We don't normally accept applications that far in advance. That's right, isn't it?
No, that's right. And in a sense, because we're part of Pupillage Gateway, the timetable for applications is really prescribed for us by Gateway. So we can only, we're making applications in accordance with their timetable, which is 18 months basically in advance. So there isn't really any flexibility about that. And in fact, I think it's now the position that all chambers, whether they're in Gateway or not, have to adhere to that timetable. So
Falak says she's finishing her law degree in summer 2020. When would she apply for pupillage? That would be January 2021, wouldn't it, Sarah? 18 months ago.
That's right, unless she's intending, he or she's intending not to start straight away, if you see what I mean, straight out. If she's not intending to go to BPTC next year, but rather do a master's, let's say, she might be looking at the following year. But yes, if BPTC is the next year's plan, then yes, you'd be applying for pupillage this round.
Super. I think we've managed to get through all the questions. So thanks everybody who stayed for all the answers, and thanks ever so much to Arabella, Sarah and Eliza, who sadly had to go to finish her work, and Jo, who is our administrative staff for setting up the webinar. Thanks ever so much, everybody. You'll be able to watch it again on the video stream on the website if you want to in the future. Thank you.
Thanks, everyone. Bye-bye.
Bye.